Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Alrighty, so now it is my pleasure to move on to introducing our fabulous panelists. We have a lot of content to cover today, so I will keep these introductions brief, but you'll hear plenty from them during the actual presentation here. Going alphabetically, I will start with Judge Jacqueline Connor. Judge Connor served 25 years on the bench and tried over 200 jury trials to verdict, and she earned national recognition for her work in jury innovations. She now brings her courtroom expertise and creative problem solving to mediation across a wide range of civil matters, most significantly for today, including construction disputes. So thanks so much for being here, Judge Connor. Our next speaker is John Hanover. With more than 37 years in construction litigation and dispute resolution, John is known for his pragmatic approach to complex, high-value disputes. He's led practice groups, served as general counsel to an international engineering firm, and is recognized as a trusted authority in construction law. So thanks so much for being here today, John.
Sure.
Next, we have Ted Levine. Ted is an attorney and a registered civil engineer. Ted draws on nearly 4 decades of experience in construction law and professional liability. His blend of technical and legal expertise allows him to guide parties through complex disputes with clarity and fairness in the resolution process. So thanks for lending us your expertise here, Ted. And last but certainly not least, we have Bob Mann. Bob is a highly respected mediator and arbitrator with a 90% settlement rate. Formerly one of California's top construction lawyers, he authored the major technical construction book, Defect-Free Buildings, in 2007, and has authored over 50 articles on mediation and arbitration. And he's handled multi-million-dollar verdicts and settlements across diverse industries, including the restaurant trade, aerospace, advertising agencies. What don't you do, Bob, is the real question. And without any further ado. Yes.
I don't take care of the garden.
But you're a burgeoning social media star with your ring lights. I love it. I will hand it over to Judge Connor, who is going to introduce our program for this afternoon.
Okay. I'm going to tell you a little bit about how we structured our approach, because as we talked about it, almost every single topic we looked at could have been a 3-hour seminar by itself or one whole day. But I think we all acknowledge that construction disputes are perhaps the most complex. I know there's more complex out there, but these have such high stakes for both the attorneys, the mediators, the adjusters, the owners, the GCs. The layer of technical detail, the overlapping responsibilities, the finger pointing, coverage, indemnity. The facts don't always dictate whether or not success is guaranteed. It's never guaranteed, but more on how the experts and insurance can shape the story, how they frame it, how they narrow the risks, and they open or close the possibility of settlement, reasonable settlement, which is always about compromise. One interesting thing about CD cases is that they hardly ever go to trial. I've never seen one. Maybe Bob, you've seen one. But I've never seen one. And so it really makes a difference in terms of strategy, whether or not one holds back their ammo or just lays it on the table, which I think is the proper approach. But it depends on how the experts frame it, how the insurance creates the framework, and whether or not possibility for settlement is open or closed. What we've presented is a 4-step framework on how to get the experts, dealing with experts first, how to get them to work for you, setting the right goals, finding the right expert, probably most important, getting and giving them the information, and I want to include the giving, not just getting, asking the right questions and getting the most from their expertise. Then we're also going to shift to the second part, which is relating to insurance, indemnity, bonds, sureties. That's so much fun. The policies most frequently at issue, common pitfalls, how to avoid them, how to handle them, and then strategies to ensure that the carriers and most importantly, the adjusters are actually prepared So we're going to try to weave these into streamlined negotiations and how to be prepared for and not be crushed by the obstacles. So you already see here 3 super experts. These are masters, and these are people that they not only know the information, they know the weeds, but they like being in the weeds. And we got our OG himself, Robert Mann, the OG of all of this. So welcome to part 2 of deconstructing CDs.
Okay, thank you, Judge Connor. I appreciate the accolades. Our goal today is to offer some concrete, no pun intended, suggestions about how to use experts effectively in construction mediation. Just about everybody knows these cases are expert driven, which means it's not news to anybody. You have to find an expert and you have to use an expert. But our goal today is we want to move past those baseline considerations and give you a much more sophisticated approach. At least we think it's a sophisticated approach. So there's 4 things here. The first is set the right goal. My colleague, John Hanover, will be talking in a few minutes about different goals, specific goals. But the most important takeaway from our perspective on this is identify the goal. That's the first step. Second, retain the right expert for that goal. Not every expert is good for every goal. So start with the goal and then think, what kind of an expert do I need? We'll talk about that a little bit more as we go on. The third thing is prepare the right way to achieve that goal. In other words, a scattershot approach, gee, I just need an expert and that person will know what to do, is probably not the most effective use of your time and money and won't get you the best result. So you have to focus your preparation to meet the goal. And the idea is that by setting the goal, retaining the right expert, preparing the right way, you'll achieve the right result. There's different results to be achieved in mediation. Some are settlement, some are not, surprisingly. But this 4th step will get you to the finish line in whatever plan or goal you might have.
So as you said, Bob, the first step is setting the right goal. And we've identified here several goals that may be appropriate goals for a mediation session. The first one, the bad faith goals, maybe that's a little bit of a misnomer. I'd probably say unproductive goals, where either you're checking the box on a mediation because there's a pre-litigation mediation requirement in the contract, or there's a court order to mediate, but the parties really don't think that the case can be resolved at that point, or there are no other intermediate goals that could be accomplished. Those I would call unproductive goals. And in that event, what we have to say about how to use experts and all the insurance requirements that we're going into and the particular difficult questions probably don't apply. In that case, it might be better to just say, we're going to check the box and we're not going to waste everybody's time. The other goals really are, I think, valid goals and like I said, intermediate steps that might be helpful short of resolving the case. So with the appropriate experts, and like Bob said, we're going to go into how to select that expert, picking the right expert, but the right goal may be to clarify technical information, where you're developing that information through the experts, you're exchanging that information or confirming that information. Each one of those requires the expert to be prepared differently, and it also probably requires the selection of a different type of expert, someone who could really get into the weeds and develop that information, come in with an open mind, ask questions, try to learn what the case is about, or someone who will exchange that information or confirm what she doesn't know and try to verify that through the use of experts. The other goal might be to narrow the issues, where you're going to take things off the table at that mediation session. And that can be very effective because ultimately you're going to strip the case down to the issues in dispute and use the experts to get at those issues, but first use them to narrow those issues. With influencing a future conversation, it may be necessary to have a day, and we'll talk about this later too, a tee-up day or an organizational day, where the experts are really sharing what the case is about, sharing what the kind of complications are, the complexities are, but no one's expecting a resolution that day. But ultimately, you may achieve a resolution at a later point based on that conversation. So those are the goals that we've set out. The next question is, how do you retain the expert? So Ted, I think you're going to take it from there.
Yeah, so under the concept of retaining the correct expert, we're going to go over the a little movie version of this, the good, the bad, and the ugly. Fortunately, I get to talk about the good stuff, the good here. So certainly in retaining an expert, and especially in a construction case, because as Judge Connors indicated that they are and can be very technical, you want to get a expert that is able to express themselves and the concepts and the complexities adequately. So you want an expert that is experienced and certainly understands the nature of construction disputes, whether involved contractor and construction and construction defect type issues, even some types of disputes which are more technical, such as scheduling issues, which can be very technical, design professional, design claims, design defect type claims. You want to make sure you get the proper expert who has the proper experience. And in the same vein, and this is so important, certainly to the entire process, but especially in the mediation, and I have seen this happen where someone brings in an expert and they start making their presentation, and it's pretty clear they don't have the knowledge or the expertise in the specific area, such as, for example, in a design professional case where the expert doesn't really have the experience in the discipline that they are in effect defending. So you want an expert who is clear, concise, able to present their positions adequately and strongly. You want an expert at the same time who can build a consensus and is well prepared, and someone who makes a good appearance and can through their presentation, or certainly if it gets to a deposition, their testimony, be able to come across as being authentic, because that ultimately is what's needed if the case proceeds to a trial or an arbitration. But this authenticity will certainly come through as part of the mediation settlement process too, and so that's where that authenticity becomes important. At the same time, the expert needs to be flexible and explore solutions, not just be dogmatic on their positions, but listen to the other side. And that will then engender the confidence of who you want to view as the attorneys and the expert wants to convince, such as the mediator and the other side, and even the insurance carrier representatives for the other side, who then you're looking for them to make payment ultimately on the applicable insurance policy. So you want an expert who is not only can present their case, but is flexible, listens to the other side, is curious, and willing to examine all positions so that you get to the best presentation that they can make. And maybe the last, but not least, is an expert who knows, as I'm saying, what to say it, how to make a presentation, understands the process, the construction process, the mediation and litigation process, is a true forensic expert. But what to say, when to say it, and when to keep quiet. And I've had many experiences, including as a mediator. I'm sure the other panelists here have seen it, where the expert just keeps going and ultimately starts digging themselves a hole. and they're hard to stop and to shut down and create problems for the party that they're acting on behalf of. So a good expert knows keep it concise, keep focused, and when to stop and just keep quiet and be confident in their position.
Okay, I'm going to talk about the bad expert. By the way, for those of you who missed the pop culture reference to The Good, the Bad, the Ugly, that was a 1966 spaghetti western directed by Sergio Leone, starring Clint Eastwood, who spends most of the movie grimacing and squinting. But it's a terrific movie. I highly recommend it. So what makes an expert bad? At the highest level, an expert who's unpersuasive is a bad expert, because the essence of this whole thing is using this expert to achieve your goals, and that means that person has to be persuasive. So what makes an expert unpersuasive? Well, a lot of things. One of them is experts who are inarticulate. Even if they are super knowledgeable about the subject matter and in command of all the facts, they're bad because they cannot communicate clearly and persuasively. They stumble, they get thrown off the track, they don't have a consistent narrative. All of these things impede their ability to effectively communicate. Inexperience, of course, is almost a threshold. An expert who is inexperienced is not going to be persuasive because nobody is going to trust that person's opinion. Experts who are poorly prepared. Experts who are poorly prepared are going to see their credibility and your credibility in the case plummet faster than a hammer that's going to get dropped on your big toe. Somebody comes in and they just don't know what they're talking about because they haven't done it, because they've been lazy or too busy or unfocused and things like this. They're not going to do you any favors. Ted talked about the idea of authenticity, which I think is very important. Experts who are inauthentic, meaning, are they boastful? Are they self-aggrandizing? Are they off-putting? Are they rude? Are they arrogant? All of these things affect the ability of that expert to be persuasive, which is the benchmark that you're looking for in that expert. And of course, experts who are untruthful or present facts inaccurately are going to do serious and considerable damage to your case. One comment about making inappropriate remarks that, and Ted touched on this, knowing when to be quiet. I had a recent mediation where a very, very otherwise accomplished expert, when I would come back into that room in the process of getting offers and counteroffers, the expert was advising the plaintiff's lawyer on the amount of the offer and counteroffer. And not only did I feel that it was very inappropriate, I also felt that his advice was just wrong. And it was a major impediment to the resolution of the case. The last point is, since a large part of the work of a good expert is consensus building, an expert who's confrontational and anti-consensus building person is very, very ineffective. And sometimes it gets to the level in terms of being obstreperous. I have had instances where experts are calling names and saying very, very derogatory things about other parties and experts in a case, and it's very harmful. I'll leave you with this, because you may be wondering, well, how do I avoid this bad expert? It's maybe urban myth, but trial lawyers sometimes say when they pick a jury, they would like to have everybody on the jury be someone they'd like to have lunch with. Think about using that metric when picking an expert. Think to yourself, is this a person I'd like to have lunch with? And if the answer is yes, you're probably on the right track. If the answer, when you say to yourself, would I like to have lunch with this person, is absolutely not, maybe it's not the right expert. Let's go to the next slide.
Okay, I get to, I guess I'm dealing with both the bad and the ugly, but instead of authenticity, I like to use the word integrity. If they have integrity, then I trust them more. I've had situations just as Bob has where the expert couldn't just answer the question. They had to pack it with stuff. It seems to me that the known hack, and how do you find out if they're known hack? You can't just figure it to me if you just want to have lunch with them, but check them out find out what their reputation is. Oftentimes, the attorney himself or herself will find out that they've got a person who's known by the other side as a hack when they're already too deep into the litigation. Now they're kind of stuck. Credentials alone are not going to make it, just as Ted and Bob had both said. I think you've got to have the practical experience as well. And if you have a bad expert, to me, it's almost worse than no expert. The internet and public documents expose a lot, contrary positions they've taken, challenges that have come to them, the fact that they've become advocates so that they lose credibility. They can't just answer the question. The way they perform on cross or when challenged to me is way more critical than how they present on direct. And the one that just can't answer yes to a weakness or no to a weakness. Instead, they have to explain, they have to keep on going, they have to pad their answer, as if they don't trust the attorney to come back and say, well, you said no on this question. Can you explain that a little bit more? Let the attorney control it. But for them not to be able to answer a question for me as the fact finder and as a mediator is the quickest thing I do to just pretty much find everything they say of a little weaker authority. I think when you have someone who can't concede the weaknesses, who can't just be honest about what the problem is, you don't have the consensus. I think the clients are led the wrong path by having expectations that just cannot be fulfilled. I think it alienates the other side, and in terms of the people with the money, it makes them less willing to stretch a little bit and make the concession that they otherwise perhaps don't legally have to make, and it's a problem either way. I had a case recently, no, not too recently, but one where there was a challenge on cross, and they didn't have a record of what was provided, so they couldn't really say that they'd seen this, that, or the other thing. They had not been provided with critical exchanges between public agencies and the GC or the owner. They were very vague about contradictory information. They couldn't answer a straight question on cross, and they tended to be very vague about their positions when it wasn't even necessary. And as far as I was concerned, that expert was of no value at all. I think it's especially hard if the lawyer, him or herself, is not familiar with CD and expects that what they're telling them is accurate when it's not, or they have no way of really evaluating it. Perhaps the lawyer is more tuned in on what is the fair result, when that fair result, whatever they think it is, cannot be accomplished because of all the layers of complexities and the different responsibilities and the restrictions on either what's available legally and or what's available in real life. The person's judgment proof, they don't have money, they're at fault. Deal with it. We got to deal with it. But the expert has to be able to understand and still maintain the independence and their integrity as someone who's just calling it like it is.
So one of the best ways to use a good expert is to have that expert tell a story. And I know, we lawyers and trial lawyers in particular think about using an expert to tell a story in advance of a trial or in advance of an arbitration. But telling that story can be really effective in mediation. So I want to recommend that you consider how best to use the expert to do that. Now, don't confuse telling a story with advocating for the case, because as I think Ted said, or Bob, that we're not suggesting that your expert be an advocate. That's not necessary, not particularly helpful, because it will drive the parties farther apart than actually bring them closer together. But the experts can be very effective in finding the drama for a case and identifying in some very concrete way, even when it's not concrete at issue, Bob, but identifying in a very concrete way what those issues are. So I've seen cases where parties have built models of the issues at hand, meaning, if it's a bathtub and the way that bathtub was flashed or waterproofed, actually building a bathtub and showing how it was done or should have been done correctly and how it would be done or was done in that particular case. Same thing with a shower pan. I've seen that example, and with roofing and how the building, the roof layers were to be lapped and were inaccurately or incorrectly lapped. So think about how to bring that story to life, because that's going to impact the rest of the negotiations, and identify for all of the parties what the risks are, which is really what that expert is trying to do, not advocate, but identify what the risks are going forward. If there's a smoking gun, great. I had a case where the issue related to mold and mushrooms. There were mushrooms the sizes of cantaloupes growing out of interior apartment walls, growing out of stairwells. And as part of the discovery in that case, the plaintiff's lawyer had learned that there was a boat manufacturer that had used the wood press board that was the exterior cladding for this apartment complex. So that lawyer got the files that were, in some storage facility, and was able to look through those files and discovered there were hundreds of letters from boat owners who said, quote, "This product should be used only for mushroom farming." Once that was part of the mediation and it was displayed for everybody, everybody got the picture. Bob, I know you talked about a case where somebody did a computer model that showed areas of leaks and colored those leaks in blue dye. And they did that test, and the building looked like a sieve, and it was all very dramatic and all very obvious to everybody. So doing that can really shape the mediation, and that's part of the preparation, I think, that you have to talk about with your experts. So let's go to the next slide.
So this next slide talks about preparing the right way. So we kind of come full circle here to our basic premise of establish the goal, create a plan to work that goal, and then implement that plan. So implementing the plan means, in a given case, first of all, explaining your goal to the expert. Don't assume that your expert understands what to do and how to approach the case. So for example, instead of saying to an expert, give me a defect list and a cost of repair, or give me a defense cost of repair, or a defense scope of repair, you might want to say to that expert, if you're on the plaintiff side, this case is all about finding an insurance coverage. So you, Mr. or Mrs. Expert, your job is you have to look for resultant property damage, something that we're going to talk about a little bit later in the program. So I want you to concentrate, expert, on resultant property damage. Let's say it's a delay case. Maybe there are very onerous contract provisions, which is a typical thing in a public works case, and maybe they weren't met by the contractor. Your goal might be to focus on that contract language, in which case your delay expert should be looking at those contract terms and demonstrating why they were breached. If, for example, the great story in your case is the suffering of the plaintiff, your expert has to tell that story. That's how you plan your work and work your plan. If the great story in the case is for every $100 that the plaintiff spent to repair a house, $5 was spent on repair and $95 was spent on transforming it from a tract house to the Taj Mahal, maybe that's the story that your expert needs to say. So in other words, the concept is tailor your expert's work, plan your work, and then work that plan. Let's go to 10.
So continuing with the proper way to prepare the case and for the expert to get the case ready for their counsel. If there's an insurance carrier, their insurance carrier, as Bob has indicated, is certainly the presence of insurance. We'll talk about this is very important. But to get it prepared the right way, to then support the mediation process, and so the best result can be obtained at mediation. And in settlement, of course, if that can't occur, then you also need to be prepared for trial, and the mediation being the first step towards that. So the good expert, and we've been talking about this, will be adept at developing information and asking the right questions, and asking those questions not only through a review of documents and project information, but also asking those questions and obtaining the information through interviews with project participants, if depositions have been taken, of course, interviewing the client as appropriate, but being forensic. This is what I call being forensic and curious and asking questions so that you aren't just telling the other side and telling people what your, as the experts, beliefs are, but you have actually, through all an information gathering process, a forensic process, then can support your opinions and do it in the right way, being authentic, evaluating risks, as John said, which is certainly very important for an expert to include and have a concept of when they're doing their work. But not just being ready to tell the other side and be possibly even possibly being inauthentic and adversarial about it and non-believable, but taking all the information, asking questions, and being prepared to then present that in the best way. And part of this is certainly being transparent and being trustworthy and being seen as being truthful. If an expert is not transparent and appears like they're hiding information, that can be certainly everything from being a knock on that expert's credibility to being the death knell on their credibility if it's perceived that they actually have information or know information or aren't appreciating what's available and are hiding the truth and aren't being transparent. And finally, confirming information and reviewing the relevant documents, information, and being, as I say, curious about it, wanting to learn, including from the other side. And that's part of the, as we'll talk about here in a moment, as part of the mediation process, teeing the case up for settlement is obtaining information through often presentations. We call them dog and pony shows, etc. But having that exchange of information, both pre-mediation, during the mediation, to then seek both what actually happened, what the cause of the delays were on the project, for example, what the cause of the defects were. John's example of even going and getting, one side getting the information as to the problems with the wall board that was being used, to gather all that information to support their position, but also appreciating and utilizing information from the other side so that you can then support your position, and we'll call it what it is, and even be ready to dispute the other side to better, to be more credible, to be credible.
If I can add one thing too, I know that Bob and Ted both addressed this thing about getting the expert to focus on what we want them to focus on. I think the attorneys have to be cognizant that that instruction to the expert is going to be available in discovery. So you don't want it to sound like you're telling them what the answer is. This is what I'm buying you for, sir or ma'am. Just understand how it's to be phrased as something that can bite you, even if it's perfectly innocent. Just be cautious.
Yes. Well said. And still continuing in the same vein, the goal here is to influence not only the present discussions, but a good expert and an expert preparing correctly the entire case and understanding the entire case and understanding all the dynamics. A good expert will do that, whether it's a smaller case or certainly a larger case with multi-parties, multi-issues. Will understand the overall dynamic, as I say, but also understand the risks and even the legal issues. They're a forensic expert. They should understand, have some understanding even of indemnity and insurance and where they're headed and how they're supporting the party and the attorney who has retained them to get to a result. So they need to tell a story. We've talked about this the same vein. Tell a good story. Tell a great story. And whether, through and these days, especially as we all know, in the age of mass media and social media, etc., that everyone, and we know jurors are very visual, and so use visuals, use graphics to tell the story. Insurance is very important. This concept, of course, runs through our entire presentation here, that you want to have a focus and understanding of insurance coverage so that then the insurance that is involved, which is obviously and certainly very important in construction disputes, will then hopefully certainly step up and assist in getting the case resolved. And same concept here, master the details. The expert needs to really drill down, master the details, understand them, so that it can then, the resolution of the case can then be achieved through this entire penumbra of efforts that the expert has utilized to prepare the case to be ready for settlement, presentation, mediation, settlement, getting the case settled, and ultimately trial if needed.
So you've got the right expert, you have the right goal, then what's going to happen? How are you going to move that forward and move forward with that expert to actually achieve a resolution or to achieve one of the other goals you've set? The concept of a tee-up day, it's sometimes referred to as an organizational meeting or a strategic planning meeting, is to figure out where to go from there. And what I mean by that is what the process might be, what the information that needs to be exchanged is, how you're going to do presentations or not do presentations at that point, and really use that as a day to stage for the ultimate negotiations that are going to happen in order to get the case resolved. So Bob, I'm going to turn it over to you to talk about what really happens on a tee-up day so that we can get to the insurance issues that I know are going to be part of that tee-up day too.
Okay, thank you, John. So in discussing how to use experts effectively for a successful tee-up day, you might think about the analogy of an aviation checklist. So, pilots use checklists so to avoid human error. They want to make sure that they've remembered everything that they need to do before they take off and land the plane. So think of this as a checklist, especially the boldface. So what do we have to do? You have to publish defect lists, and they have to be complete and thorough and understandable. You have to publish a cost of repair estimate. This is on both sides of the case, by the way, because in a well-prepared case, there will be not only a plaintiff cost of repair, but a defense cost of repair. And I think that has serious implications if it's presented and if one is not available. If a legal analysis is necessary, this has all got to be published in advance of the tee-up day for use at the tee-up day. A resultant property damage analysis has to be published. So note that it says well in advance of the tee-up day. Well, why? Here's why. Most of the money in construction defect cases and construction disputes generally comes from insurance. In public works cases where you've got larger contractors who may have money or surety who might have money, insurance is important, but is maybe a little bit less important. But in private works cases, it's all about insurance. Insurance carriers live in an intensely bureaucratic world. They live and die by rules, regulations, reports, multiple layers of authority. As a result, to succeed, you and your expert have to play by their rules. This is mostly about timing. Defense lawyers, adjusters, experts need time to review, digest, discuss, and decide about what your expert is saying. They have to set reserves. Adjusters have to get authority so that they can come to the mediation with enough money to get the case settled. All this takes time. When we say well in advance of the tee-up day, that means a minimum of 60 to 90 days before the tee-up day. Having your expert publish all this information a week before the mediation is completely ineffective, because almost every single time the defense lawyer and the adjuster will show up and say, we haven't had time to review this and to set reserves and to get authority. So sooner is always better. I think we can go to the next slide. So allocated demands. This is the next thing on our checklist. If we have a case where there's a general contractor and multiple subcontractors, typically you're going to see allocated demands from either the developer or the general contractor to each of the subcontractors. So again, this is a checklist item on your aviation checklist, and it's a timing item. Defense counsel needs to review this. The experts need to review it. The carrier needs to review it. A note on pass-through demands. All of us, my colleagues here today, and I see this all the time. But frankly, pass-through demands, even though they're common, are rarely helpful, because the general kind of the knee-jerk reaction in the subcontractor group to pass-through demands is, really? No, whatever. And then everybody spends a lot of time talking about what the allocation really should be and how we're going to kind of get our arms around it. Let's look at slide 15. So what's left on the tee-up day? If you've done your preparation, what's left on the tee-up day? You know, in thinking about this, I remembered I had an English professor in college who was obsessed with outlines. And he would always say to us, if you have finished your outline, what really do you have left to do? It's much the same with the tee-up day. If you've planned your work, if you've gone through your checklist and you've published all this information, your tee-up day is really going to be a day to kind of solidify all of this and get the case set up and teed up for a resolution. Now, on a tee-up day, you might have a dog and pony show. In my view, that's a particularly appropriate thing and use of time on a tee-up day. Nothing wrong with that. A dog and pony show, however, on a money day mediation, that's not a good idea. That's usually not a good use of time and energy. So your expert is probably going to have to be there to answer questions from defense experts. They might be lingering questions from experts. Almost certainly there will be challenges to allocation, and almost certainly, despite everybody's best effort to just get all of the facts on the table, there's going to be requests for additional information. In thinking about, having your expert there on the tee-up day, lawyers sometimes say to me, well, can I have my expert on call? I don't want my expert to be there all day. Well, maybe, but usually not. I think it's a better idea to have these people there. If you, for some reason, have to have them on call, it's not a good idea for an effective use of an expert to have some expert driving around in his or her car and attending the mediation by cell phone. This sends the wrong message, and it's a really, really ineffective, I'll be diplomatic, ineffective approach. I'm keeping an eye on the time. Let's try to look at slide 16.
Okay, I've got 16. With the expert presentations, I want to just remind the viewers that when we're talking about tee-up days and the advance work, this is all stuff that's done before the mediation. A lot of this cannot be done at the mediation. Sometimes it is done. I know that sometimes they, with the trust of the lawyers and the trust of the experts, one of the most productive ways I've seen is to have the experts all get together in the same room without the lawyers When the lawyers show up, it tends to create posturing and more biased presentations, I think. But with just the mediator there, and it's, again, trust is required, with the mediator having them walk through issue by issue by issue and have the experts indicate what the problems are, see where they have agreement, narrow down the scope. This has happened in cases where the range of say 4 or 5 or 6 experts who come in, the lowest range of damages is or repair is low 6 figures, the highest is mid 7 figures. To have the mediator there keeps the experts from being overbearing, keep them on goal. The whole idea is we've got to settle. This is a business decision. It's a practical decision. It's not about fairness. Fairness or whatever the legal excuses it can be made is basically that 4-letter word that just doesn't work. The information, again, for everybody has to be presented and given. Everybody has to know what they've got in advance. And as it's already been referred to with respect to the adjusters, there are so many layers that they have to go through. They have to rely on the neutral experts. They have to rely on the what the mediators telling them, what their lawyers, excuse me, not the mediators, what the lawyers are telling them. And last minute discovery just cannot be, it's not going to be effective. I remember hearing too many times that the large loss committee only meets once a month. So if information is not presented by the adjuster, they might have 60 days of delay before they can get to the large loss committee to make a decision on their authorization. I also hear about adjusters who tend or have not trusted their own attorneys, that they don't even tell the attorneys, their own attorneys, what their authorization is. And sometimes the excuse is they've been sold down the river instead of being protected. And the level of trust has to be something that we do have to deal with. In terms of the expertise and the importance of understanding what's in the policy, this is getting a little bit beyond, but in terms of the exclusions, I think all of us have seen cases where you have policies with the roofer, where there's a roofing exclusion, a grader with a soil exclusion, pollution policies with mold exclusions, hypertechnical dig alert requirements, where GCs are insured or supposed to be added insured on every policy. There's a lot that goes on. There's a lot of finger pointing, and the experts have to be ready and willing to back off when it's not something that they can either express a decision on or willing to concede so that everybody can reach a consensus.
Let me just add one comment on that slide. This ties back to setting the goal and identifying the goal. Because if the mediator knows what the goal is and can work with both sides, these are all tools in the mediator's, toolkit. Using any one of these may be the best approach, but without identifying the goal and knowing what you're trying to do, it's very hard to identify what the right tool is.
So now, getting into the second part of our presentation here is the very, very important but somewhat technical and detailed issue of insurance, indemnity, and bonds in construction cases and construction mediation. So the role of insurance in resolving construction disputes is certainly, as we've talked about here thus far, is very important vis-a-vis getting the proper information to the insurance carrier, identifying the insurer, all of those considerations. But what we're going to do here in this portion of the presentation is discuss really two concepts. And both involve, and this is the important sort of overarching 5,000, 10,000 foot portion of this, they both involve transfer of risk. And transfer of risk, anyone who is involved in the construction industry, whether it's the actual construction or design industry itself, and here, those who are in the business of resolving construction industry disputes should know and appreciate the concept of risk transfer. And what risk transfer is just as it sounds, it's placing the obligations and legal obligations, including the obligations to pay damages or claims on another party. And it's very, very important, certainly, in determining how and if a case will settle. Just briefly, also recognizing our time constraints, insurance is the transfer of risk from an insured to an insurer in exchange for payment of a premium. Pretty basic, we all probably know this. Indemnity is the transfer of risk from one party to another through usually a written agreement or operation of law. And then you have bonds. We'll be talking about bonds and those an obligation under surety bonds, which is where an insurer or surety agrees to pay a third party. So general liability insurance. This is the maybe the most common type of insurance that we will see in construction disputes. And what it's typically the insurance that covers contractors' parties for claims made in construction cases, including general contractors and subcontractors. General liability insurance provides coverage for property damage and bodily injury. The insuring part of the insurance contract states that those are the type of risks that are covered by a general liability, commercial general liability policy. But importantly, it only covers, and we'll get more into this, but general liability insurance only covers what we call resultant damage, rather than damage to the actual work or property itself or the workmanship by the contractor. It provides coverage only for damage to other property as a result of the construction or defective construction as a general concept. Occurrence versus claims made policies. An occurrence policy, generally a general liability policy, is a occurrence policy, and that means that the damage needs to occur during the policy's active period, regardless of when the claim is filed. Okay, and this is different and significantly different from a claims made policy, which provides coverage when the actual claim is made, even if the work or specifically the services may have been provided years prior. And generally, claims made policies are written for at least relevant to construction disputes for professionals such as architects, engineers, construction managers, etc. So the coverage is quite different from what a contractor's insurance may provide, as opposed to maybe professionals or design professionals, whether they're written on an occurrence or a claims made basis. And then exclusions are very important to general liability policies. The general concept in insurance is that an insurance policy provides in the insuring form the scope of coverage. Okay, and that, as you're working through and understanding insurance and insurance coverage and how it applies to construction and other disputes, the insurance, as I say, provides coverage, the insuring form, and then, and you've seen this if you've ever reviewed an insurance policy, then after the insuring form, there are exclusions, and a number of exclusions to the coverage that then, in effect, take coverage away. And key exclusions in the construction industry are workmanship, such as I just stated, for a general liability policy. The general liability coverage is not generally applied to defective workmanship. There needs to be resultant damage. There's contractual liability exclusions, although there are exceptions to this, which may even swallow up the exclusion for contractual liability for contractors. That's a discussion for another day. And then pollution exclusions, mold exclusions, those type of exclusions to coverage also apply, and you'll see in general liability policies. So the exclusions are very, very important in determining and evaluating general liability coverage. And then completed operations coverage, just generally that for in a general liability policy provides coverage for property damage or bodily injury after the project is completed versus coverage while the work is just ongoing. And so it's important that a general liability policy, and hopefully the general liability policies at issue in most disputes, and especially construction defect disputes and the like, have completed operations coverage, so that there is the policy, the general liability policy, can apply and provide coverage to the claim. Builder's risk coverage, won't spend a lot of time on this. It's a specialized type of coverage or property insurance that protects the project during construction, the structures during construction, and provides coverage for damage from perils such as fire, or wind, or vandalism, even theft. It's also known as course of construction coverage, and is essential for owners and contractors and subcontractors to have in place to safeguard against losses during the actual construction itself. It's, as I say, it's a specialized type of coverage, but is very important to have in place. There generally aren't a lot of claims issues over builder's risk coverage. If there is an event that occurs during the course of construction, such as a fire, then the builder's risk coverage usually should step up and provide the indemnity under the policy. Professional liability coverage, very important. It's also known as E&O, or errors and omissions type of coverage. This is insurance coverage for, at least in the construction realm, for architects, engineers, and other design professionals. Surveyors have professional liability E&O coverage. Construction managers, the professionals who would work on a construction project. And what professional liability E&O coverage does is it provides professionals and their businesses from claims of mistakes. There needs to be negligence or a failure to deliver on professional services as a broad concept. And this is contrasted with general liability coverage. And what's important here for everybody to know is that general liability coverage and professional liability coverage are basically two different animals. And the way they work together in a construction dispute and resolving a construction dispute is important. It's important for the mediator to understand these different type of coverages and the limits on them, such as some important limitations, issues with professional liability coverage is, we say here, policy limits. It's really an issue of depleting, or what we call burning, policy limits. And a professional liability policy, most all of them have what we call, as I say, burning limits, such that the policy limits that are stated on the policy are depleted or reduced by the defense costs, including attorney's fees, expert costs, etc. And that can be very significant because if there's a significant claim with some significant exposure to the professional, then and there's a significant depletion of those limits, in defending that case, then there may not be enough money or maybe reduced amounts available to then settle or resolve the case. And also importantly here, the policy limits can be depleted by other claims, not only the claim that's involved in your mediation, your current mediation, but there's other claims on that policy that have been, there's been amounts paid out in defense costs and even settlement, then the policy limits can be depleted by those other claims, which would have had to have been, as I say here, claims made. The claim would have had to have been made during that policy period. So second part of this is that professional liability policies are claims made policies as opposed to occurrence policies. So what's important is that even if the alleged negligence of the professional occurred possibly years before and before inception of the policy, it's the policy of the that's in effect when the claim is made that then provides the coverage to the professional under an E&O type policy.
Yeah, and if I can make one quick observation about these policies as well, many of them have consent provisions where the design professional has to consent to the settlement. And because of what are called reporting requirements to the various boards, structural engineering, architecture in particular, sometimes the design professional doesn't want to consent to the settlement.
Yes, consent, well said, Bob. Consent is very important in professional liability policies, and generally the insured and the insurer will be hopefully are in lockstep towards resolution, but it can occur where the insured, the professional, doesn't want to consent to a settlement, including because of statutory reporting limits to the applicable licensing board. Subcontractor policies are generally also written on a general liability, a CGL form. The one distinct aspect of subcontractor insurance and additional insured endorsements, which are important, is that there will be a contractual obligation by the subcontractor to name as an additional insured on its policy another party, such as usually the general contractor. And by way of this additional insured endorsement, as an add-on to the policy, it extends coverage to this third party, such as the contractor or possibly a project owner, usually in the case of a contractor owner situation, with this additional insured being covered by the policy, but not being the named insured or the primary policy holder. And it's intended, and we could do a whole seminar on additional insured endorsements and how they work, and under California law issues with respect to additional insureds. But in general, additional insured coverage is intended to protect the additional insured from liability arising from the named insureds, that is in this case of a subcontractor, the subcontractor's actions or negligence. And therefore, under this additional insured endorsement, the additional insured, such as the GC, the general contractor, obtains protection under the subcontractor's policy and can file a claim against the subcontractor policy. And importantly, and the claim is for, as I say, it's a claim for coverage under the policy. And significantly, the policy should and would provide defense coverage, that is, provide defense costs coverage to the general contractor under the additional insured endorsement.
Folks, with our last 10 minutes, I really want to make sure we can talk about some of the key issues during mediation. Ted and Bob, can we go through wrap and surety bonds pretty quickly here?
Yes, certainly. Yeah. Thank you, Katie. RAP policies also important to construction disputes, but the details of them somewhat esoteric. What they are is a single project-specific insurance program or policy that, in effect, bundles the liability insurance into one program, one policy for the owner, general contractor, and all subcontractors involved in a project. And the benefits of a RAP policy are that you reduce disputes, you're able to have one source to go to, including the mediator and in the mediation process to resolve claims as to the contractor side of the project and the dispute. And also, just as a general practical matter, for the project, they're beneficial and can reduce costs overall in the insuring program for the policy. The two types of policies generally are OSIP and CSIP policies. An OSIP is an owner-controlled insurance program or policy, and a CSIP is a contractor-controlled insurance policy. OSIPs are owner-controlled are much more prevalent in what you would usually see. Surety bonds. Bob, you want to take that, or you want me to?
Sure. These are seen most often in public works cases because most public works projects require the general contractor to have a surety bond. So they come in two flavors, payment and performance bonds. A payment bond means that if the owner pays the general contractor and somehow that money does not make its way to the subcontractors or suppliers, for example, theoretically anyway, the surety will pay that money. A performance bond means that, let's say 3/4 of the way through a job, the general contractor goes south for some reason. Theoretically, emphasis on theoretically, the owner can contact the surety and say, you need to supply a new contractor to finish our job. In the real world, it's never quite that simple or that easy. But in theory, that's how this is supposed to operate. This is a very, very highly specialized area, and a lot of it revolves around indemnity agreements that are in favor of the surety from the general contractor, so that if the surety has to pay something, in theory, they get it back from the general contractor. In reality, that doesn't happen all that often.
So let's talk about some of the key issues that are going to come up during the mediation with regard to coverage. First of all, just in terms of a few references for people who may want to learn more about these various exclusions in these areas of disputes, there is a CEB guide on construction defect litigation that outlines the various coverages, and I would recommend that highly. There's also a Rudder guide on insurance issues, and they relate specifically to construction. There's also a multi-volume publication edited by Scott Turner on insurance for construction disputes. So if you're looking for more information, it's out there. Also, the Judicial Council forums have interrogatories that are specifically designed to get at some of these insurance issues. So don't overlook those in terms of working up the case for mediation. These are I think, the principal areas where you're going to argue about money, either with carriers or between the parties. So the first is duty to defend versus duty to indemnify. If there's a duty to defend, the carrier is going to have to pay all of the insurance dollars, particularly on a CGL policy. That's going to be much broader than the duty to indemnify. And probably the easiest example I can give is if there are water leaks, but everybody's uncertain about whether those occurred during a particular policy year, the carrier may defend, but ultimately the discovery may show when that occurrence happened, and it may or may not be within the policy period. In that event, the carrier will issue a reservation of rights, a letter that identifies which exclusion that carrier is relying on or why that carrier is saying that it may not cover particular risks. If that's the case, let the mediator know that there is a reservation of rights and share that reservation of rights letter early so that everybody can be prepared to deal with whatever that exclusion is. Allocation between covered and non-covered claims typically comes up between contractual liability and liability for resultant damages. So under a CGL policy, there's no coverage for the work itself if that work is defective, only for the resultant damage. So think roof construction, there's inappropriate lapping of the building paper, the roof leaks. The carrier is going to say, we'll pay for the resultant damage, meaning water, damaged drywall, damaged furnishings within, let's say, a house, but we're not going to pay to redo the roof itself. That's that allocation. And then just generally the policy exclusions, probably the biggest one to keep in mind are what I would call business risks, which are damage to either your product or your work is not going to be covered under the insurance provision because that is not an insurable risk. It's really only going to be that resultant damage. So the next slide, please, Katie. Stacking policies is going to be a critical issue, particularly if there's an argument about a continuous trigger. So stacking can occur either by horizontally stacking policies, which if you think about it is more like a continuum on a timeline. There may be an occurrence like soil subsidence or water intrusion or a leaky underground tank, something like that happens over time, but the parties aren't sure exactly when that happened. It may be possible to trigger coverage for multiple years and stack the policy limits for those particular policies to cover the loss. Or it could be vertical stacking, which basically would deal with the excess coverage layer over the primary coverage layer. So there may be a way to actually get the excess carrier engaged once that primary policy is exhausted. Declining limits, Ted touched on and described, I think, well in terms of an E&O policy, professional liability policy. That's going to be critical. Policy limits, you just need to know the difference between the per occurrence and the aggregate limit of a policy. It could be that a policy either from this particular claim has multiple occurrences. There could be a water leak, in month 3 of the policy, and there could be soil subsidence in month 10. So you're going to have 2 claims, each one governed by the per occurrence policy limit, but the aggregate limit would be the total of all the claims during that policy period that may be able to attack that particular policy. So with that,
last minute here, yeah. Thanks, John. We did prepare a little bit more material than we're going to be able to get to just in case today. In our last minute, I do want to kind of shift to some kind of wrap up practical considerations because I know everybody loves those. So any final thoughts from our speakers about putting the insurance into effect in mediation?
If I can just address one issue that hasn't been touched on, and that's getting the right adjuster, getting the one with the authorization. I found that Zoom helps a lot. We get a better adjuster, maybe from Chicago or Baltimore, whatever they can call in, as opposed to having a local adjuster who has to call on every call. That has made a difference. Zoom has helped.
Mm-hmm. Great. Thank you.
Yeah, I would just say about this, Katie, the key is, one of the keys is timing. Getting this information out early, exchanging the positions early, knowing the policy limits, knowing what type of policy it is, getting all of that out early and exchange between the parties and to the mediator early so that you really can focus your time appropriately on dealing with what's going to move the needle one way or the other in terms of having money available to resolve a claim.
I'll throw one thing onto the table. Read the policy. I had a recent mediation where a roofer left a roof open and it rained and ruined a house. And believe it or not, the roofer had a policy that said, we don't cover damage if you leave the roof open during your work. And nobody knew it until the time of the mediation when a coverage lawyer showed up and said, we're not covering this claim.
I have one final one that hopefully not too dry, but since we skipped over indemnity, and in the same vein as what Bob just said, read your indemnity provisions in the contracts, since we didn't get to this, and understand the implications of the indemnities, including defense obligations, which may arise from the indemnities, and including how they can, indemnity provisions, express indemnity provisions can affect settlement, such as the existence of an express indemnity can prevent parties from settling, or reasonably prevent them from settling, because they can't get a good faith settlement in a multi-party dispute. So a party can potentially agree to pay the claimant, in the case, the plaintiff, the developer, but they can get a good faith settlement on the equitable indemnity claims, but not the express indemnity if they owe an express indemnity obligation. So that party needs to stay in the case. It can greatly affect the dynamics of settlement. So read your insurance policies and read your indemnity agreements carefully and understand them.
Thank you all for those.
And reread Crawford versus Weather
Yes.
Shield. We had a very good discussion about this.
I want to comment that all of our panelists have their email addresses in the materials that you have in your email. We are here at time, so if you do have to skedaddle off back to work, we understand. But anybody who is able to stick around, we will address some of the questions. There's some good ones in the Q&A here. But as you leave the program, you will be directed to a short survey. We really appreciate if you take a couple of minutes to respond to those. And as a reminder, your CLE certificates will follow via email within the next week. So thank you to everybody who was able to join us for that portion. And we're going to switch over to the Q&A here, where we have some great questions. One that spoke to kind of choosing an expert. Somebody asked, sometimes folks who switch to expert duty let their professional qualifications lapse. How do the panelists feel about using a contractor or subcontractor who doesn't have an active license in their trade?
I have a strong opinion on that, but I think that's an enormous mistake, because if you go to trial and the first question that expert's going to be asked is, tell me what your license, and are you currently licensed as a contractor, and what's your specialty, or even a design professional, are you still licensed as a design professional, maybe in that realm? And they say no, I think they lose all credibility. I think it's a mistake.
I'll give you a contrary position. Sure. I think that the experience is very, very important. You could have a contractor who's got a current license, but he has absolutely no experience in the particular area. And you could have a contractor who comes in and said, I did this for 25 years. I retired from active practice 6 months ago or a year ago, but I've done 5,000 houses. So I'm not sure that I see it in the same black and white terms. And I think I would want to know, what is the reason for this person no longer having a license?
I agree, Bob. I always look at it as down the road, looking towards trial, what you're going to do for trial. But certainly for mediation and consulting purposes, you're correct. Yes.
We did have a great question. What does a mediator do when the defendant comes in with the position of offering nothing to resolve the case and demands a walkaway? I saw, Judge Connor, you were interested in responding to that one.
Oh, I've never seen that happen before. I'm shocked. It goes back to what we started talking about, the goal. If that really is their goal, if it truly is their goal, there's nothing you can do. And it seems to me that's a sham mediation. And if it's court ordered, I think there may be some repercussions with the court. But on the other hand, maybe just a posture. It's a beginning position. And I think as a mediator, I would really explore, are you serious? This is really where you want to go? And I'd ask, how about, what if I could get you the whole thing resolved for $10,000? Well, okay. I would just explore to see whether it's real or not. And if it's real, there's nowhere to go, but I think there ought to be repercussions if it's court ordered.
Well, Katie, I'll say one quick thing about that. There's only 3 ways to settle most construction disputes. The owner pays the contractor pays the owner, or nobody gets paid. Everybody shakes hands and walks away. A surprising number of cases get settled on a walkaway basis. So when somebody comes in and says they're looking for a walkaway, depending on the circumstances, it may be unrealistic, but depending on the circumstances, it might be a completely appropriate way to resolve the dispute.
Agreed.
Here's an interesting one as well. In a coverage dispute, how do you manage a situation where coverage counsel wants to participate in the mediation but does not want plaintiff to know that they're there?
Yeah, I mean,
Well,
I think those coverage issues that I was, identifying are so critical. It's very difficult for a coverage counsel to remain anonymous, but I understand they don't want to necessarily signal that there might be a deck relief action or signal that these are going to be issues. So, yeah, I've had situations where you just raise all of the coverage issues and debate those issues with the other side. But I typically find it's more effective if the coverage counsel are known and can participate in that discussion.
Typically, they're used to provide, as it may be beneficial or not, provide leverage towards reaching a resolution. So,
And is that a conversation that you as the mediator would have with coverage counsel?
yes,
It is.
yes, definitely.
And when would you try to do that? Is that like a pre-mediation call thing, or how do you handle that?
Very often they just show up without anybody knowing in advance that they're going to be there. In fact, I think this is an increasing trend. More and more, you could have maybe 2 or 3 or even many more mediation sessions, and then a coverage lawyer shows up and says, we're not going to pay this claim. And then it sets everybody back on their heels. But we are seeing this more and more as the carriers become more resistant to paying money to settle cases, which is something that I think is happening right now.
Hmm.
But I do think, Katie, in terms of disclosing that information up front and from counsel's perspective, trying to get the case resolved, if you can encourage those coverage counsel to reveal what those disputes are going to be about, get them to participate, get that information out 60, 90 days beforehand, give the mediator time to have those pre-mediation calls to address those issues before you get to even a tee-up day. It's all going to give a greater likelihood of trying to resolve the case, or one of the other goals of narrowing the issues so you can get to what's really going to be in dispute and everybody can dig down on that.
We have time for just a couple more questions here, being cognizant of your afternoons. We had a couple of clarification questions. So one is, can you distinguish between the cost of repair versus property damage? And is property damage somewhat incorporated into cost of repair? I think, Bob, you had that slide.
Sure. I think the important thing to understand is the difference between what you can claim as damages and what's covered under the insurance policy. You can claim, to use John's example of the faulty roof that leaks water into the house and damages the hardwood floor and the drywall. You can claim legally the cost of repairing the roof, the drywall, the hardwood floor, the furniture, etc. That's not the issue. The issue is, what is the insurance company going to pay for? They don't pay for the bad workmanship of the roof. They only pay to repair the resultant property damage. So the practical problem that this creates is, in my example or John's example of the roof leak, let's say that all those things together are $100,000, but only $5,000 of it is the resultant property damage. $95,000 is the cost to replace the roof. You could get a judgment for $100,000, but the carrier is only going to write a check for $5,000 if they care to. And then the plaintiff is going to have to figure out, can I collect my $100,000 judgment? That's where the risk comes in because of the limitations on resultant property damage coverage.
Right. And that cost of repair, I mean, you're going to need that cost of repair to identify what the property damage is to some degree. I mean, it could be, personal property, but for instance, in that roof example, Bob, if you have water that intrudes and some of the members of the roof are deteriorating or they have mold. So you've got consequential resulting damage there. And you're going to have an expert who's going to have to say, this is what it's going to cost to tear those damaged members out and replace them, distinguishing that from doing the work right in the first place, which the carrier won't pay for. So it is complicated in terms of what that expert's going to have to opine about.
Mm. And as one final question here, somebody asked, to prepare for mediation, is it advisable to present the total cost of repairs to all defendants and allow them to determine their respective shares? Or are we procedurally obligated to allocate costs among them beforehand? More relevant to you even is, what approach is more effective?
Bob, you address this. I'll let you. Yeah.
I don't think there's any particular legal requirement to actually allocate. I mean, you're going to have a general contractor who probably has express indemnities from each one of these subcontractors. And even without that, the general contractor's got equitable indemnity rights by operation of law. So what happens at a trial? The plaintiff says, you caused $1 million of damage. The general contractor says, you, plastering subcontractor, you're responsible for 20% of this damage. You, window installer, are responsible for 15%. You, framer, are responsible for 50%. But as a practical matter, to answer the question in context of the mediation, I think it's imperative that there be allocations well before the mediation. Otherwise, everybody's going to walk into the mediation and all these subcontractors are going to say, what are we expected to pay? And if they don't know what they're expected to pay, they will not have had the opportunity to speak with their expert, their defense lawyer, their adjuster, and set reserves and obtain authority. And the whole mediation session will be a waste of time.
It may be important on this, certainly, is for the plaintiff to have their expert or experts prepared to explain the allocation and why it was done that way, rather than just some number out in the ether.
I think that can help as well. I think that's a very, very good point. Some plaintiffs are willing to do that, and some plaintiffs say, you owe me $1 million. I don't care who pays it and how. That's your problem, not mine. I think that your approach is generally more effective. Work together. It's a collaborative effort.
Yes.
Mm-hmm. Well, I think we are getting close to time here. I want to be thoughtful about everybody's afternoon, and especially appreciative to you, all of our speakers, for sticking around for a few more minutes here. I do want to wrap us up here, but thank you so much for sharing your expertise, sharing your time, and especially for taking into consideration the questions that our previous attendees submitted and putting this program together as a follow-up companion piece to the last program. Thank you all for joining us for your lunch hour. Reminder, your CLE certificates will go out within next week over email, and please take a few minutes to respond to the survey that you'll get kicked over to. Thank you all once again. We appreciate your afternoon time, and thank you to our speakers today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.